started. This is the Peter Chase Neumann Lecture on Civil Justice, which has become a cornerstone of this College of Law's Civil Justice Initiative. Civil Justice Initiative seeks to elevate the American civil justice system and to train the next generation of great trial lawyers and advocates. This evening we explore what lawyers and pundits often refer to as the disappearing jury trial. We will explore it with a person whose work in the courtroom, in the larger community, and in the academy, and I hope more often that academy includes Arizona law, affords him an unmatched up-close view. Let me spend just a few minutes telling you how Steve Susman became the country's leading expert on and proponent of the jury trial. A native Houstonian from a venerated legal family, Steve's love for the law came naturally. His father was a prominent figure of the Texas bar, and his mother a true pioneer, having graduated from the University of Texas Law School in 1934. He attended Yale, earning his undergraduate degree in English and simultaneously securing his reputation as a person who can identify a need and a way to respond to it. Online reports recount examples of his entrepreneurial spirit, setting up a travel agency for his classmates. And for any current student who needs us to explain travel agency, just let me know. Running a student laundry service and leasing graduation regalia. After Yale, he followed in his mother's footsteps and went to the University of Texas, where he served as editor-in-chief of the Law Review and graduated first in his class. On graduation from law school, he clerked in the Fifth Circuit for Judge John Brown, one of the great civil rights judges in American history. And then Justice Hugo Black, also a great civil rights judge, at the U.S. Supreme Court, where, according to one of Black's biographers, he became the first law clerk trusted enough to draft opinions for the justice. Steve joined a large Houston law firm, became a partner in rocket record time, then left practice briefly to teach at the University of Texas Law School, where he pointed out to me, it was great and interesting, but teaching is hard. In 1980, he founded Susman Godfrey, a firm specializing in commercial litigation. His national reputation as a plaintiff's attorney was first established that same year with a $550 million award to victims of a nationwide price-fixing conspiracy, the largest jury verdict of its time. Many more successes have followed. Steve served clients on both the plaintiffs and defense side in cases that frequently constituted water cooler conversations and have frequently inspired significant coverage in the national legal press. Among them, representing House Speaker Jim Wright in his 1988 ethics battle, representing the Hunt brothers in the largest lender liability case in history, and representing the state of Arkansas in a milk price-fixing case. The firm of Susman Godfrey has over the years become a leading national law firm. It now has 140 lawyers, I believe, in offices in Houston, New York, LA, and Seattle. Lawyers from the firm are here in Tucson this week for a retreat. I hope enjoying our beautiful setting. Far beyond the confines of practice, his interest and passion for the constitutional guarantees of trial by jury led him to establish the Civil Jury Project at NYU School of Law. The project has three aims: to assess the current role and status of the civil jury, to reimagine new ways to preserve the right to trial by jury balanced against other efficiency interests, and to educate various constituencies about the jury trial. He travels the country educating the bench and bar on a series of jury improvement lunches. One was held today here at the college, and just a few hours ago, indeed, that was the first such lunch here in Tucson. As you might imagine, Steve's work consistently earns acclaim within the legal and business communities. 2006, he was honored as one of the nation's top 10 litigators by the National Law Journal. He's been included in the best lawyers in America for each of the last 25 years. And in international commercial litigation's worldwide annual poll of lawyers ranked him Litigator of the Year in multiple years. And finally, and this is my favorite, in 2010, the Business Insider named him one of the 11 lawyers you definitely do not want to go up against. So I was especially impressed about this, not only that it's a great list for a lawyer to be on, but I can't think of a single list with a professor or a dean, anything like that. So, through the generosity of Peter Chase Neumann, our alum and a longtime plaintiff's lawyer in Reno, Nevada, he cannot be here today in person, but he is very much here in spirit and healthy and doing well. And with Peter's grace, we are delighted to welcome a man who, in the words of a young colleague said, is a force to be reckoned with, a generous soul, and a man with boundless energy. I give you Steve Susman.
It's great to be here. How did I get here? Why am I here? For about 50 years, more than 50 years now, I was trying lawsuits, mainly jury trials in Houston, Texas. Houston was really the world center of the trial world bar. During the 60s and 70s, any list of the 10 top trial lawyers in the world would include 5 or 6 from Texas. There are a lot of explanations for it. We had heavy industry, a lot of industrial accidents along the Gulf Coast. Banks, a lot of oil litigation. But there are explanations for why it was that way, and that's the world I grew up in. And over the years, I'm going to show you some statistics of trials disappearing. I've lived a disappearance. So about 5 years ago in my law firm, we decided to give all of our associates an annual questionnaire, like a satisfaction questionnaire. You know, if you get a hotel, how do you like this, or how do you like that, and what can we do to improve? And one of the open-ended questions, we got an answer that said, when are the partners in the firm going to stop lying to law students about being able to give them trial experience? And that kind of hurt. And I realized that, in fact, while we were doing a much better job than other firms, it was hard to call what we were doing giving them trial experience. There just were not enough trials. So I then thought, well, what can I do to solve the problem? And I began giving speeches on the disappearing trial. Someone heard it, put me on the American Board of Trial Advocates Committee, Save Our Juries. And then I realized that working through bar associations, that's not the way to go. The lawyers were really excited twice a year when they came to some exotic place like Tucson. And on Friday, they worked for 2 hours in a committee meeting, and then on Saturday, they talked about their tea time. On Sunday, they'd plane home and their docket the following week, and you didn't hear from them for another 4 or 6 months. So it was not going to do that way. And then I came up with the idea, by this time I had opened an office in New York, which was one of our successful offices, and I came up with the ideas of, well, maybe I ought to try to save jury trials by creating a center like the Brennan Center in NYU. That was the model. As the Brennan Center does, and they try to protect the right to vote. And it turns out that when I began looking at a little, studying a little, the right to jury trial was more important to the founding fathers than the right to vote, because it's mentioned 5 times in our founding documents: the Declaration of Independence, Article 3 of the Constitution, and in 3 of the Bill of Rights. So this would be a noble cause. Brennan Center's protecting the right to vote, and the project, the Civil Jury Project, would protect the right to trial by jury in civil cases. And that's when we started about 3 years ago. I am the executive director. I still practice law. I try most of part of the time. But I'm having a wonderful time going around and talking to people about a problem that every trial lawyer and every judge knows, and that is that trials are disappearing in this country. And so our goal with the Civil Jury Project is to ask the question, why is this happening? Do we care? Should we be worried about it? And if so, what in the world can we do about it? Let me start with, and I'm talk to you about what we discovered. The first question is, this shows you what has happened in trials. The red squares are jury trials, the blue squares are bench trials. This is all federal courts across the country. 55 years of statistics. Beginning in 1962 when I graduated Yale College and ending last year. And you can see that the number of trials per judge average has dropped from around 10 to under 2. Actually, jury trials are a little over 2, bench trials are lower. And in retrospect, I was not aware of the fact that bench trials had disappeared as quickly as jury trials. And this is pretty good evidence, I think, of the fact that there's not some peculiarity with juries that makes people want to avoid them. The proposition was, the thesis was, well, jury trials take too long, they're too expensive, it's too probable you're going to get an unexpected, unreliable result, a runaway verdict, and juries are susceptible to special advocacy, lawyers who are trained to talk to juries. But that cannot explain why bench trials are also disappearing. So what's happening in this country, and I should have called the project instead of the Civil Jury Project, the Civil Trial Project, because all trials in public courts are disappearing. And are people not having disputes? If they are. So where are they being resolved? Well, we know one big answer is arbitration. Arbitration is now, the Supreme Court has fallen in love with arbitration. If the arbitration word is anywhere in a contract, then you're not going to get into court. Whether you read it or not, you may have been a click-through contract, and when you buy a song on iTunes, you waive your right to a jury trial. How come it is that the Supreme Court allows American citizens to so easily weigh a constitutional right as important as the right to trial by jury? But that has happened, and so a lot of what would be in courts is now in conference rooms. And there's a big danger here. So it's just like, I think there's a role for arbitration, but it's like there's a role for private schools. We need to keep in this country public schools healthy and viable and vibrant. And I think dispute resolution falls in the same category. There's a role for private dispute resolution. If grown people want to settle their disputes by arm wrestling or casting lots or smoke signals or whatever they want to do, God bless them, they ought to be able to do that. But they shouldn't be able to force others into these contracts of adhesion to give up their right to trial by jury. And if we continue to go in this direction of all disputes being resolved either before they go to trial or privately in a conference room, it's a serious danger to the rule of law in this country, in our democracy. The rule of law depends upon you having a result that people know. Jury verdicts are public in the conscience of the community. What do they think? And so if you analyze And this, by the way, this whole, a few other slides, the average today in Arizona, the average federal judge tries 2.2 jury trials a year and less than one bench trial. These are civil cases. And even those big figures are terrible, I mean, numbers are low. Arizona comes in 24th in the nation in terms of the most jury trials per judge. The percentage of civil terminations, this is, now you could see the number of trials might be varied depending upon the number of filings. Maybe people aren't going to court anymore. Maybe tort reform has taken so many claims, out of the system that there's fewer cases to be decided. But if you look at the percentage of cases that are terminated by a jury trial or bench trial, look what's happened to that. It's under 1%. Jury trials, they're down to a 0.5%. So these are pretty terrible numbers. And one worries that with that kind of trend, are we going to have any trials left at all? And the thing becomes very reinforcing. What happens is that the judges say, we would like to try cases, but the young lawyers come out also don't know how to do it. And then they go to the big firm and say, discovery law firm, and they're good at taking depositions and reading a bunch of documents, writing briefs, but they don't know how to try cases. And therefore, they don't even want the opportunity to try cases. We say, we'll set it for trial next week. 2 weeks, we say, no, Judge, no, thank you. The lawyers like me, the people who have firms who are trying to train young lawyers like y'all, we say, how can we train the lawyers? How can we get them trained without having enough trials in the courts? So that's this kind of thing that reinforces itself, and it's not good for the rule of law. And this is I heard one of the justices on the Supreme Court said that maybe it wasn't the Supreme Court, it doesn't sound right, but I heard a judge say that the common law is in danger of disappearing in this country, where judges write opinions that get in the books because it's all being decided privately. One of the biggest dangers to the survival of public trial is the fact that we did a study, we had a survey of people who are not lawyers. 80% of non-lawyers in this country, Americans, when asked the question, have the number of trials in the last 10 years gone up or down or stayed the same? 80% say it's gone up, which is totally inconsistent with all statistics. How can they be so wrong? Well, remember, for 30 years now, we have lived in a regime where tort reform the tort reform system has tried to close the courthouse doors to people who are injured. So we have lived through medical malpractice reform, securities law reform, antitrust reform, class action reform act, security reform act. All these reform acts, it means taking away cause of action from injured people. So, having this trend is intentional. It didn't happen accidentally. The public sold a bill of goods, litigation. The word people associate with lawsuits is frivolous lawsuits. And the Chamber of Commerce and Business Roundtable was very successful in convincing the American people that there is a litigation explosion in this country, that there are a lot of runaway verdicts, that juries are dangerous. So many of my social friends say, why don't we have juries? Why don't we have professional? Well, why don't we have professional juries? People who are paid to decide, okay, well, that's what judges are. But people are, it's a very dangerous situation we are in today. And the fact that no one understands, because they watch all these movies and television shows, that in fact, we don't have a litigation explosion. I feel more comfortable talking to you, by the way, than I do talking to a bunch of judges, because I get adversarial with judges. This is not a good thing. I still have a law firm. But I do get adversarial with the judges. I got adversarial with a judge, a federal judge, a lovely woman from Los Angeles yesterday, because she was saying, I asked her why she doesn't allow the jury to ask questions. Or why she, there's another question I got, why she doesn't, and she says, you know, it takes too much time. I don't want the trial to go fast. I want it to be over fast. And so I said, you know, what I can study about the history of the Seventh Amendment, the founding fathers understood, they were not stupid, they understood jury trials were going to be longer, more expensive, more uncertain, more susceptible to eloquent advocacy than bench trials. Actually, the history is very clear that who really pressed for the jury, the Seventh Amendment, were the southern states, because they wanted jury nullification in lawsuits brought by big banks on the East Coast against debtors in the South. The southern states ran up a lot of debt during the Revolutionary War, and when the French banks and the New York banks began collecting, the southern states wanted to repay the currency they were minting themselves. And, you know, well, that's why we have a contracts clause in the Constitution. I mean, you know, Madison and Hamilton, you can't have a federal government unless you honor contracts to pay back your debts. But the Southerners still believe that even though a contract existed, a jury would be sympathetic and not throw people who couldn't pay their debts into jail. And that was clear. So, you know, and everyone thought that did not like the judges who the king was appointing. The Peter Zinger case in 1736 was all about jury nullification. He had, a New York publisher, had criticized, had been critical of the governor of New York, said he was incompetent, stupid, and corrupt, and the governor of New York wanted the judge to charge him with sedition, which was simply saying something false at the time. Truth was not a defense. I mean, saying something derogatory. If it said something derogatory, you were guilty of sedition. So he insisted on a jury trial, and the judge tried to get the jury to convict him. Not terribly, I mean, we've heard of judges, federal judges, and other judges. The Managerial trial recently, that judge wanted a different result than he got from the jury. So juries in this country are independent, and our founding fathers understood they would be independent and protect us from corrupt judges, judges who were under the influence of big business or government, judges who were appointed by the governor or the king and felt loyal to him. Well, think how the times we live in. We have a president who wants loyalty from his judges. We have lawyers in this country are all up in arms about judicial independence and worried about attacks on the judiciary, litmus tests for the judiciary, wanting judges to be loyal to whoever appoints them. The Brennan Center at NYU. In this country, 95% of all cases tried publicly in public courts are tried in state courts. The vast majority of them are elected. And even the ones that are appointed initially, like here in Arizona, have to stand periodically for retention. It's an election. Brennan Center did a study completed last year that said that they concluded that judges who depend upon the public to get them their job or to keep their job are more likely to favor the interest, the side of the case that they think will have the most ability influence in getting them reelected or keeping their job. They did some studies, and so, you know, how would you like to be a litigant in a state court against a big company that you know makes enormous contributions, unbounded by Citizens United, to some judge's campaign to be elected or to be retained? It would be a pretty horrible experience. So, the jury is that you can't bribe a jury, it's a cross-section of the community to come into court, and if we're going to protect the other rights that the Constitution gives us, we need juries to do that. So I think it's pretty easy to convince people, and we need to do a better job, we lawyers, civic teaching to our fellow citizens about the reason for jury trials and why they are as important today as they will ever be. There's another thing about jury trials that not only do you create a public verdict that people know, which is important. I mean, look at the Me Too movement. I forgot to add that. The efforts on the part of companies or law firms to they want to avoid class actions, so they insist that consumers sign away their rights to trial by jury by agreeing to arbitration. They want to avoid harassment suits, so they insist that associates and partners sign arbitration clauses to make sure that if they have a dispute with the firm, it's not held in a courtroom where all this dirty lemon will come out, but it's in private, resolved in private by arbitration. So it's more important today than ever that we keep jury trials alive and well and important. There's also been some research done to show that people who serve on juries and actually deliberate are more likely to vote than people who don't serve on juries. So it's kind of, and when you talk to people, so I've talked to more jurors around the country than any other person alive, I think, and you know, 99% of them had loved it, would do it again in an instant. And so, and they just love the opportunity to work with people from all walks of life, from all demographic groups, and to try to deliberate and solve problems. And it does tend to make them better citizens, I think. Every trial lawyer I know will say that when a client loses a jury trial, they are much more likely to accept the result than if they lose in a bench trial or if they lose in arbitration. In a jury trial, they don't blame the jury, they blame their lawyer for not effectively communicating to the jury. If they lose a bench trial, the judge is corrupt, the judge is stupid, the judge is biased. In arbitrations, can even be worse. So jury trials are good, and I think we need to figure a way to keep them. So what can we do? Well, we have made a list of about 17 reasons we think jury trials are disappearing. And I think it's important, first place, when you pick something, you've got to figure out the reasons why that's happening to some extent. But more important, you've got to figure out what you can do something about and what you can't do something about. So what can we lawyers, law students, judges do something? Well, these are the things that are very difficult to change. Professor Langbein at Yale Law School wrote a seminal article on jury trials and said they were doomed. Trials were doomed with the enactment of the rules of civil procedure that allow the parties to discover facts before they have to go to the courthouse. Because in the olden days, you had to go to trial to figure out what the facts were. I mean, surprise was a trial lawyer's dream. We all love surprise. Now it's like, okay, we got to turn over every stone, look under every rock, scorched earth discovery, because we don't want to be surprised. And associates, like when you become associates in a law firm, you're going to feel the same pressure. We got to figure it all out before we go to trial, because if we don't, senior partner's going to get mad, the client's going to get mad. Well, if you figure it out before you go to trial, then why can't you settle the case? That's what the mediator would tell you, and there's some truth to that. You figure it all out, why can't you settle the case? Man, in 1983, it was very smart. I mean, it's just a history of the attempt to co-opt judges and make them think that the only thing important about judging was efficiency. Clearing your docket, getting rid of congestion on the docket, and not being late in doing it. And so, that gave rise in 1983 to Rule 16 of the Federal Rules of Civil Procedure, which is the rule that allows the judge to bring all the parties into a pretrial conference and set all these time limits and schedules, kind of be managerial. So it's a managerial judging that also took a lot of cases out. I think it was yesterday, I'm losing track of time. What I found across the country is that, and in most places what usually happened was there was a central, in many places there was a central docket. All the cases, certain judges were assigned to try cases. That's all they did was try cases. They did not do any pretrial. No disputes, no motions. It was just a trial. Other judges were the judges that handled all the pretrial procedure. And that seemed to get a lot of cases tried. It was effective. But it may not have been efficient. So the managerial judges is the idea is, well, the judge lives with the case, gets a case, it's her case for the duration. So she knows the lawyer, she knows the issue, she has been through the discovery disputes, and, is okay. So, but that kind of managerial judging has also had an effect on trying cases. If you go to any federal courthouse in this country on a weekday, or any time during the weekday, anytime during the week, you can shoot a cannon through the hallway and not hit anyone. Most of the courtrooms are empty. The lights are out. There are very few exceptions in this country. Oh! I got that idea, by the way. I actually had a summary judgment argument a few years ago in a case in federal court in Phoenix, in that big Sandra Day O'Connor courthouse with all the glass. Mm-hmm. And I went up there to argue the case, and there was not a soul in the hallway. I mean, there was no one. And I had my phone with me, and I began taking pictures of, the courtrooms that were dark, the rooms that were closed. I was struck by the fact that the reality is so different than what the judges want us to think it is sometimes. You hear about the judicial emergency. What's the emergency when you have like 2 trials a year? What's the judicial emergency? Last week, the House Judiciary Committee passed a bill, approved a bill, and be debated, to create 52 new federal district courts judgeships in this country. For what? The averages will even go down worse than they are now. The trials per judge, we add 52 judges. New courthouses, why are they being built? This is a problem in this country, and I think we better figure out what the truth is and get good statistics before we make these enormous, expensive decisions. And then you have judges tell me, like the judge did yesterday, that We need to get this done quickly. Why? Why do we need to get it done quickly? So these are, in any event, you'll see, elimination of causes of action, tort reform, medical reform, all kinds of things to take away the causes of action. Then we create procedural screens. The Judiciary has created it to make sure that only the creme de la creme goes before the jury. Not a close case. Juries would be good in close cases, but we only want to put before the jury the best of the best. So you have the Twombly problem, whereas you don't plead a plausible case, you get thrown out on motion to dismiss. Then you used to not even be able to know when to file a motion to dismiss. Now one is filed in every case in federal court. Every case. And it's expensive. Summary judgment. You can look at what happened to the number of trials in federal court. If you look at just number of trials, I don't have that graph here. It dropped like a rock in 1986 when the Supreme Court passed the summary judgment trilogy, which says that summary judgment should be granted unless, it made it much easier to get summary judgment. Daubert, you had to have a plausible case. Daubert rules where you can't even get an expert to testify unless the judge first determines that the expert is reliable. Another way to screen things from going to a jury trial. And if you want a jury trial in this country, you have to go through all these hoops to get it. And that's expensive. Caps on damages. There's no longer a pot of gold at the end of the rainbow. Whether it be, I'm told today that there was not tort reform in Arizona. That's a lawyer in the audience said that. And the presiding judge of the Superior Court said he's wrong. There's all kinds of tort reform. And not caps on damages yet, but joint and several liability. He was telling me, he said that guy was just wrong. So that lessens the incentive to go to trial. 46% of the cases in federal court are MDL cases, where there's this need to dispose of a whole lot of cases. This is one here there is one thing that arbitration offers that courts cannot impose confidentiality. So, today, people want things confidential. Non-disclosure agreement. Having watched TV every night, doesn't every American now go with non-disclosure agreement? Everyone's an amateur lawyer now. And so that's, I don't want you to. If you want to go to my law firm, sign a non-disclosure agreement. Because I don't want you talking about being an American lawyer. Jury consultants, some of these things are good, by the way, not bad. Today we have a cottage industry growing up around the courthouse where jury consultants tell you that they can do a mock trial and predict the results. And they're right, they can predict the results. And it makes me mad every time you have to go to mediation. These former federal judges, state judges in mediation say, you don't want to go to trial, Mr. Susman. Tell my client I'm there. Like, I can't tell my client that. Telling my client, sir, you don't want to go to trial. You can't trust the jury. It's like going to play roulette in Las Vegas. These people who are supposed to defend the institution of our public justice system are now making $750 an hour, telling our clients, don't go to trial. It's like playing roulette. That's bad too. But it is true that if a jury consult, if you do a mock trial and the jury consultant can predict the result, and both sides do a mock trial, and it's almost always the case that those are very similar results, we should settle the case and not go to trial. So that enables us kind of to have a practice trial, and maybe that's one of the reasons. Then, and most important, and really one of the things that I want to talk a little about before us is these are the things we can change. Here's a list of reasons we can change. expensive discovery. That's all of our associations and bar organizations, trial and judges are concerned with that and are doing something about it. They do, for example, when I began during the 70s and 80s, into the 90s, the most expensive part of discovery was deposition. They were not limited in time, they were not limited in number. And deposition was very expensive because you had lawyers on both sides, a videographer, court reporter. Well, that has been brought under control because courts now in the country saying, we take 10 depositions, you can't go for more than 6 hours or 5 hours. You are limited in what you can go. And so what is the big expense today is ESI, electronically stored information. Again, you got to think as a lawyer, how can it be that computers are making something more expensive to do rather than less expensive to do? Only in the legal profession do you have paradox that computers, and the reason that's true is that you can find all the documents. You can produce them instantaneously. You can produce any group of words, key terms, whatever you want, but that takes no time. What is taking the time is that the producing party is insisting upon having lawyers like y'all sit at a computer screen and read documents so that nothing irrelevant gets produced, only relevant stuff. By the way, privileged stuff you can keep out, but you can find, if you just search, the computer can find a lawyer's name instantaneously too. So you can just list the lawyers and they kick out all documents. Withhold them all to have a lawyer's name and something to look at. But it's looking at the other documents because, and why are businesses so reluctant to produce irrelevant documents if there's a protective order, if you're required to give them back, showing, in fact, you have an obligation as a lawyer to give back anything that's irrelevant. So why don't we just, judges could change that and make it very inexpensive to have electronic discovery, but they aren't. Delay getting to trial. The judges here, I think, do a great job in your state court. They give early trial settings. They give definite trial settings. And I didn't get the chance to ask them what their position is on continuances, but last court, the year before we went to court, Gorsuch made a speech where he said 90% of the cases set for trial in this country get continued. That is a hell of a figure, isn't it? 90% get continued. What's happening in our profession is that nothing happens when it should. Everything gets postponed. And if lawyers knew that if you took a case, the case could get set for trial for 5 months from now, and the only way a continuance can be granted is when the lawyer died or got very sick and the judge died, you would pay attention to that case. You can get the job done in 5 weeks, 5 days. Just tell us how much time we need. But instead, we just let things drag out for 2 years so we can handle instead of 5 cases, 50 cases. Judicial insistence on mediation, that's another thing that's taking some cases. But again, that's a good thing. I'm not against mediation. I think lawyers should spend a day with their clients in a conference room discussing the merits of their case. They should have to do that before they waste the jury's time hearing a case. But again, what judges are doing now, and it's horrible, is they are requiring you to go to mediation before the judge rules on dispositive motions. So you go into the mediation, you don't know how the judge, lazy judges, glad I have this audience, who do not want to do the work, and just send you to mediation and hope that you will settle a case and get it off their docket so they don't get reported. And you know, the statistics are really interesting. I didn't say that. I love doing this because I think about things like this. It's very easy to get statistics on the judges who are late, tardy, the slowpoke list. You can get a slowpoke list in every court in the country if you haven't moved off that by a certain time. You cannot find out how many days that judge has spent on the bench trying lawsuits. That statistic, while available, is not published. And not available in the federal system without a freedom of information request. Because I've tried to. I can get the figures for the District of Arizona, but I can't get it on individual judge basis. Lack of real trial orders. Well, hopefully, that's why I'm here. Hopefully all will become trial. Hopefully we'll do things that, but we are working on that. How do we train lawyers in a place where, well, there are a lot of mock trials. So we at our firm, we insist that young lawyers do things in mock trials. We have a rule, if you write it, you speak it. We urge judges to pass a rule that says, if you will tell me, Judge, that a young lawyer is going to argue a motion, I will give you a hearing on the motion. But if Susman's going to do it, forget it. I'll rule on paper. I don't need to hear him anymore. So that's great. And you have that rule for trials. If you will tell me that a young lawyer is going to be the lead counsel of the trial, I'll give you a preferential setting. Otherwise, get in line. Maybe you'll get a trial the next year, maybe you won't. Judges can help us get young lawyers educated and equipped. And the effect it's having, and judges also, I asked some jurors in Idaho the other day whether there was a case where one side had 4 lawyers at counsel table and the other side had 1. Now, in the olden days, it was good trial, good gunslingers were lonesome operators. You know, you went in court, you wore your boots, you had a cowboy hat, and all the jurors paid attention to you and listened to you, and you didn't have an army with you because that would, the big companies would have an army. That's changed. It's changed now because jurors like it. Jurors want to see young lawyers operate. And they have made it very clear, the judges are getting made it very clear, that it doesn't concern me at all, it doesn't concern jurors, that 4 lawyers are having speaking roles, or 5 lawyers, or 6 lawyers. It's not bad, particularly if some of the lawyers are diverse lawyers. And the young lawyer rule is having the effect in some places where it's adopted of getting female lawyers, which is a big problem, trial lawyers, on their feet more. Because as often or not, women will do a disproportionate amount of the writing in law firms. And if there's a way that we get them on their feet because the judges are encouraging that, that's great too. The repeat litigants' perception that juries exclude educated, skilled citizens, and that juries are deprived of decisional citizens, developing judges and arbitrators. So this is a big problem. If the trial lasts too long, the only people who are going to be on the jury are unemployed people and retired people. So most of the forward-looking jurisdictions, fortunately, Arizona is one of those, encourage judges to set time limits. You get 20 hours to try the case. Each side gets divided equally. Each side gets 10. They call it clock trials, on the clock, where you have a time, chess clock, and the judge keeps time and tells you how much time you have left. Every lawyer that's done that says it makes for a much better trial. Every juror, the one complaint we hear from every juror in the country is, why did the lawyer repeat themselves? The trial lasted too long. We could have decided this 2 days before we were allowed to deliver. The time limits are great, and they are being adopted for it. And in a time-limited trial, the trial lasts 5 days. A CEO, a highly employed, educated person, is not going to get off for hardship. They're going to have to serve on the jury. It's only if the trial lasts 5 weeks, the judge will let those people off. So but that came up today, and it was a very interesting thing today. Again, one of my learnings. So Arizona, in 1993, because there was a judge here named Dan, and I don't know whether he's alive or not, but I have not been able to get in touch with him. He was a state court judge, and he was very interested in jury trials. And he had a committee, and in 1995, a report to the Supreme Court of Arizona called Power 12. And it was a report on jury reform. Arizona adopted it in 1995. And this is where all the professors, who are law professors, who are studying jury behavior, come to do their study. Because more has gone on here than any other state in the country. Things like giving, why you ask, I want to show you a video, but it's not working. But why in normal jury trials, most of the courtrooms across the country do we instruct the jury at the end rather than the beginning? What's that about? It's totally contrary to the way we do things. Before you try to assemble a complicated toy you bought for your kids, you read the instruction. You don't assemble it and then read the instruction. It's why aren't the judges giving full instruction to the front? Why are jurors allowed to ask questions of witnesses when they don't understand? Why do we tell jurors, you cannot even talk to other jurors about the evidence until you go into final deliberation? Even when all of you are sitting in the jury room together, and it would be so natural to say, that last witness was a scumbag. Or do you understand what she said? Or why did they call that witness? Or what was the purpose of that? Again, an innovation that this is permitted in Arizona, not permitted in Texas, not permitted in New York. Why isn't every juror given a copy of the written instructions at the beginning? A copy of the verdict form with the questions that they have to answer? Again, permitted in Arizona. The question that came up today, and I asked the judges because we had 2 federal judges and 4 or 5 state court judges. I said, how is it that the state courts here, where judges are appointed and then subject to retention elected, why is it that those judges are much more forward and reform-minded and innovative than federal judges who are appointed for life and don't have to worry about what the lawyers think about it? To me, it's something we need to study. Why is a federal court behind state courts like the state court here in Arizona? And then we have things that, like the public perception. I mean, clearly got we did a terrible job of the profession explaining the copy that calls copycat. When there is a jury verdict which is not understood because people were not at the courthouse and did not hear the evidence, good lawyers around the country have to form a SWAT team and go on the air and be available to talk on MSNBC. And talk about, and go on all the talk shows, CNN. And so, a jury did that. The jury was conscientious. They followed the judge's instruction. And there were a lot of explanations for what they did. And we have to defend the jury system, because otherwise, those who are not in favor of juries will claim that the result was terribly unreasonable. So that's important that we go around defending juries and explaining that. Someone told me today when I talked about the McDonald's case, he said, the judge told me, a state court judge said, have you ever heard of a case like the McDonald's case? That's 25 years ago. Since? Big silence. I was silent. I haven't. I mean, all the cases are going to jury trials. Isn't it strange? This is a problem that we haven't had more McDonald's cases. So, it has, I've now come to the end of this lecture, and I'll be glad to take any questions. I'm going to a law firm retreat in Dove Mountain this evening. And I want to thank the Arizona School of Law for inviting me here and making it possible. So, I said, Professor Robertson, who you're very lucky to have him, because I got to know him at NYU, where the project is located. I get in every class. teaching because he's awesome. I mean, real practical he is. So I said, I'll come back to speech because my law firm's having a retreat out there. And I want to give the young lawyers, our associates, we have 130 lawyers, I want to give our associates a lesson on how you voir dire a jury selection. I have questions. So I don't know whether any of y'all went for all I know are going out to Double Mountain, but there are students that are coming out to play jurors tomorrow. I'm going to be the judge, and two of our really experienced partners are the whole morning as an exercise. How you effectively, because in what happened there too, federal courts took away lawyers' rights to ask questions before they make a judge. Because the lawyers were arguing too much. They were not asking questions, they were making their arguments. Judge O'Malley would brag that when he sat down and voir dire, the case was over. He was right, it was over. If you were against him, he argued the case so much that it was over. So the federal judges didn't like that. They took away at federal court lawyers' right to participate in voir dire. And now about 50% of the judges are giving it back because the lawyers are paid. We are not asking these horrible leading questions and arguing our case. Some of the judges tell me, I call them and say, wouldn't you like to conduct a voir dire? Those young lawyers say, no, Judge, I don't want to do it. You do it. You're doing a fine job, Judge. So isn't that interesting? I mean, we argue we need to have the right to ask questions of our own little jury, and yet we're not training people to do that. Thank you very much, and anyone that have any questions, I'll be glad to answer. Question?
I have a question.
Yes, ma'am.
Hi. So I really appreciate your talk, and one thing I wanted to find out about was what advice you would have to students about thinking through how they would be trial lawyers in the context of civil rights. So, for example, I was in a law class in, I think it was 2014, where I had an observation sitting in the back where female students would raise their hands and then begin their question or their comment with, I don't know if I'm wrong or not, and they would say it not, and then they would give the comment. And then male students would sometimes not even raise their hands, but just begin speaking, and they didn't have the prefatory, derogatory self-statement. And it just seemed to cut across like racial and ethnic boundaries. It would just be a gender thing. And it happened consistently, day after day, week after week. And it was like not even like a 1L class, it was an elective class, so there were students from all 3 years. And it was shocking. And I have been in English classes as well where that would happen. And it just seems
what
like...
kind of classes?
I'm sorry, I was in English classes as well where this would happen. So it seems like if trial lawyers are going to be, like you're saying, female associates, I just don't understand how we're going to train female lawyers to be assertive in the courtroom if when they're training students, they're acting like that.
Well, I don't know. I can tell you that we are now getting at a law firm.
Yeah.
So we are getting as many women percentage-wise as graduated from law school.
Yeah.
Getting them is easy. Keeping them until they become partners is more difficult.
Yeah.
Because trying cases is stressful.
Yeah.
Period. If there's a lot of trial, you're going to be willing to go out of town. I mean, being a trial lawyer is difficult. And I would say our women lawyers who are most successful are those who have husbands that are willing to do take a lot of responsibility at their homes. That's happening. But we have done all kinds of things to try to, that is a problem. We don't have the same percentage of women as partners in the firm as we do as associates. So we're having a more difficult time keeping them. But everyone's working on that. The bar is really, there's a lot of work going on there. There's all kinds of institutes. You can go to programming sponsored by the ABA or one of the organizations. What do we do to win more opportunities in the courtroom? Trial. Yes, sir.
As either graduating law students or practitioners, what are some things that you can practically do to try to either address the problem or start the reversal of the trend? I mean, if I have a case, I can caution my clients that I think this is a good case for a jury to decide, but there's all these other considerations. So what can a young attorney do to help this problem?
Well, if you're on your own, I think you should call up someone like me. No, you should say, I want to go, and there are lawyers who will do this. Like, I've got a case that I think is worth trying. I'd like you to look at it. And would you come sit in the second chair with me? One of the things we're trying to promote is something called a second chair mentoring program, where for young lawyers who are in their own firm who do not have senior partners who will sit with them. And this is a problem where the lawyers like me will do second chair. You will be the lead counsel. I'm not getting paid. The trial has got to be time limited because I can't do this for 4 days or 5 days. I can certainly do it. The judge has got to, we've got to make sure that if I do it, I'm not going to be sued in malpractice by your client if something screws up. So the judge can kind of give me some help there. The judges have to cooperate. They have to let me sit there at the last minute. And so I would look for a mentor to give you some sense that you're not going to be alone when you go to trial, in which you may be more willing to go to trial.
I think my question was just more not being unsure of being successful or failing at trial, but getting a case to trial or doing something as an attorney to fight the trend that you're noticing and is having such a problem.
Well, you're not going to be able to do the kind of things I need to go around like. Of course not. But you can do. The judges today talk about here. They haven't done it yet. But publicizing on the court's website, the federal court's website, pro se cases that are trial ready. Now, you don't want to get a pro se case at the beginning because it's some nut job. The case is probably subject to a motion to dismiss. It probably shouldn't be dismissed. And all you will end up doing is writing a brief. Okay, well, everyone's entitled to a lawyer, but you don't have to do that with your time. But once the case gets beyond the summary judgment stage and becomes trial ready, no more motion, that's a perfect case for you to be assigned to. And we need to get the judges to put them on the website where you can find them and go do some of that. It's hard, people are young lawyers. A lot of them are going to U.S. attorney, district attorney. But in the civil area, it's hard. Yes, ma'am.
I was curious if you're familiar with Pima County's Fast Start program and whether you think that's a right direction in order to preserve the civil jury trial.
A lot of it.
Okay.
The judge do. So I asked him I know what it is. It's a pilot program. It's an exception. Here in Arizona, y'all carry arbitration to the television screen. There's apparently a state statute that says that the amount of controversy is under $50,000. You are forced to go to arbitration. But the Supreme Court has authorized a pilot project in this county, which they're opting out of it. And so the judge said he had a great afternoon with 2 lawyers who came to talk to him. They talked for 2 hours each, and about how they were going to do this, could be done. So I think it's a great idea. It is a short trial, very little discovery, only a very short period of time for trial, limited witnesses. I don't know whether experts are allowed or not, but it's It's the idea to have a cheap way of trying. Another thing that I learned today, fascinating. One of the judges got on the panel accidentally was a family law judge. And he was saying that in his court, instead of trying an average of 2 cases a year, they're trying 10 cases a year. And he says because of the family court, there's no discovery. No. I mean, you actually go to trial to discover what the facts are. There's none of this depositions and pre-trial discovery that you have in civil law. Okay.
One more question, or one more, then we'll...
Yeah, do you think for young lawyers that want to get trial experience, do you think going the criminal route early just to get good experience as a trial lawyer and then going civil would be the best? What do you think about that?
No. I'll tell you what the problem is. So, if you represent the government, you are representing the 800-pound gorilla. You do not have to do nothing. And most prosecutors don't. And you don't have a budget either. You don't have to do things for free. When we get people, we have had people, but still do, who come from the U.S. Attorney's Office or the prosecutor's office, the biggest thing we teach them and have to teach them is you do not have it in your budget. And also, if you want documents, if you want depositions, you say, pretty please, may I have them? Sir, ma'am, could you please, you have to be a lover, not a fighter. Because being a fighter, you can fight when you get in the courtroom. But if you fight before you get in the courtroom, it's too expensive now. It'll keep you from getting in the courtroom and reduce your efficiency. So be a lover in civil litigation. Be nice, be sweet, be civil.
That is a perfect theme on which to end the thing.